I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. What is an equipment finance agreement? For many years, we had two types of equipment financing. One was a true lease, fair market value lease, in which the lessor is the owner of the equipment and the lessee merely has a leasehold interest. The second is what is commonly called a buck-out, lease intended as security, security lease, dirty lease, financing lease, a number of other names. That's a lease in which the lessee, at the end of the term, either owns the equipment outright or purchases it for a nominal value, such as $1. The problem is that the dollar-out lease was treated by some courts as a true lease. We have a case, for instance, in Florida, in which the fact that there was a dollar purchase option did not protect the lessor from a claim of liability for damage caused by the lessee under that state's insurance laws. In response to that, and for a couple of other reasons, a number of practitioners began creating the Equipment Finance Agreement. The EFA is simply a loan agreement. It doesn't purport to be a lease in any respect. The EFA has the advantage of making it clear that the lessor, or in this case lender, is merely a lender and is not responsible for damage caused by the equipment. We have precedent in a number of jurisdictions to that effect. So the EFA is a loan document. It generally will look a lot like a lease. As a matter of fact, we sometimes take clients' leases and convert them into EFAs, which is a fairly simple process. But it is important to note that the EFA is not a lease and should not look too much like a lease in form. There are a number of things that an EFA must have. For example, the amount of the principal, the amount advanced, should clearly be stated. Now, this does not mean that each payment has to be broken down to principal and interest, but it should be something that would allow the lessee, we believe, to calculate the interest rate if it is not stated anywhere in the document. 2, there should be a clear grant of security interest. The EFA, as a loan document, is going to have to be protected by the filing of a UCC financing statement. And the grant of security interest should be clear, which it may not be in a lease. 3, EFAs are likely to be subject to usury considerations. That should not be the case in true leases, and it's a little questionable, although probably the case in leases intended as security. That means that we think a usury savings clause and the analysis of usury in another of our videos should be considered carefully. Other changes include a different statement of remedies and mentions of Article 9 rather than Article 2A of the UCC. For further information, please visit our website, www.leaselawyer.com.